In this case, we have what is mildly described as a very vulnerable victim.
Two young parents accused of killing their infant son.
Elevated charges of homicide by abuse could be added.
Chilling new discoveries from the baby's injuries that could up the stakes for prosecutors, and more shocking details from the investigation that will have you scratching your head, because one of them is that the boy's mom filmed a TikTok dance, allegedly, in the same hospital room as her dying son. We're on the case, presented by Law&Crime. I'm Chris Stewart. Well, hey guys, real quick, we partner with Truthfinder for the public record searches that we do here at Law&Crime. It saves us research time so we can focus on reporting crime, not paperwork. And you can use Truthfinder too. You type in a name, you can find addresses, criminal history, and more. It's our go-to tool for checks, and it's one of the largest search services in the US. With a subscription, you get unlimited confidential searches to check on new neighbors, vet people you meet online, or find someone to reconnect with. You can also look up registered sex offenders nearby, or even do a background check on yourself. Stay informed, stay safe, check public records with Truthfinder now at truthfinder.com/OTC. A 7-week-old baby boy dies after spending 5 days in the hospital fighting for his life. Just 7 weeks old. And then 3 days after he died, his mom and dad end up behind bars, charged with his murder. This is an ongoing case, and there are a lot of questions in this case that have yet to be answered as this legal process is just unfolding. But what we know so far from this investigation, it is not just heartbreaking, it is just shocking, including the alleged choices that the young parents made leading to this tragic situation that's playing out in Pierce County, Washington. So let's get into it. According to a probable cause affidavit from the Lakewood Police Department, quote, on March 5th, 2026, officers responded to Mary Bridge Children's Hospital regarding a child abuse incident. One of the officers spoke to a social worker at the hospital who reported that a 7-week-old infant boy had been transported to the hospital by West Pierce Fire and Rescue for a life-threatening emergency the day before. The social worker stated that the infant, and this boy is only being identified as NC, was admitted to the hospital and was not expected to survive. So in the police report, the child's parents were identified as 21-year-old Mark Anthony Clammer and 19-year-old Alyssa Vanderbeck, and they were allegedly no longer in the hospital when police got on scene. Now, the injuries that this baby reportedly suffered are horrific to hear. I will warn you of that, and we're going to review those details shortly. But before we do, we need to talk about what happens when the parents of this boy returned to the hospital and police were there. So when the parents get back to the hospital, they're contacted by one of the police officers who, in the report, writes that they found their demeanor to be unusual considering the gravity of the suspected offense and the condition that their child was in. So that certainly raises some suspicion right there. According to the report, each parent was then interviewed separately on what exactly happened to their newborn, this newborn now fighting for his life in a hospital room. At this point, officers already know that the first 911 call, that came in the day before on March 4th, 2026, around 2:21 in the afternoon. And that's when Clammer, who's the dad, reported that his 2-month-old child wasn't breathing. So here's what Clammer allegedly told police. He reported that he had fed the infant approximately 4 ounces of formula out of his bottle, then another ounce 2 hours later. So everything to that point seems normal, right? And he stated that the infant became fussy during the second feeding. And that also is very typical if you have a 7-week-old child. But this is where things get allegedly dark, because he says that he picked his child up when he was fussy and did that motion, which he demonstrated by making a forward and backward jerking motion. And he reported that he saw the child's head jerk back pretty hard before trying to catch the child's head and pull the infant to his chest. He also later stated that he knew that he had jerked the child in a manner that he realized was rough. Now, when asked what NC looked like after he forcefully picked him up, Clammer replied, quote, he looked normal. I mean, he wasn't crying. I thought he was getting tired. Now, sometime between 1 o'clock in the afternoon and 1:15, Vanderbeck awoke, that's the mom, and she and Clammer took a shower together, according to police, and they had NC, the baby boy, in his bouncer, and they had that bouncer in the bathroom with them. So you're starting to see here some details that would definitely raise suspicion for law enforcement if you were in the room listening to this. Because jerking a 7-week-old baby in a rough motion, just as Clamor allegedly told law enforcement, that doesn't sound like a safe recommended method when it comes to calming a baby down or keeping a baby safe. Now, we still don't know the full story here because both of these parents were interviewed by police, and the affidavit continues with the mom, Vanderbeck's, point of view of what happened to this point. So, when they get out of the shower, she saw that NC appeared to be breathing abnormally and exhibited some sort of abnormal eye movements that got progressively worse over time. And at one point, she, quote, really forced his eyes open and said that she and Clamor tried to rouse NC by stimulating him physically, which included shaking him in a panic. Again, not something that sounds, and I'm not a doctor, like a recommended method for this situation. Now, when asked if this could have worsened the child's condition, she replied, quote, like he could have had minor shaken baby, and then it got worse. We were so scared. This is a terrifying situation for any parent to be in. And remember, at this point, it is believed that Vanderbeck didn't exactly know why her son was acting the way that he was, but there's a lot more that we need to get to here. Because you do think from at least her perspective, 1 minute you're taking a shower, then the next minute your newborn appears to be in serious medical distress. And you have these young parents, the pressure they're feeling, I'm sure it's unbearable. And this is what Vanderbeck says happens next. She recorded a video and she started reaching out to friends and family asking for medical advice. She thought her child might have had a seizure and said that he seemed, quote, distraught with his eyes open, but he was unresponsive. It's important to note that she didn't call 911 at this point. According to police, multiple videos were taken by Vanderbeck of her infant child, and they were very shocking. The videos were filmed in multiple locations in the residence and showed the child in serious distress, according to law enforcement. Specifically, the child can be seen with labored breathing, which included posturing and grunting. And this is indicative, according to law enforcement, of the type of breathing that is telling you that something is seriously wrong. The child could also be seen with one eye partially open and the other partially closed. Now, at one point, the child appeared to have stopped breathing. Now, let's break this down for a second, because first, I want to read what Clamor said his response was to seeing his child in this distress. He was believing that it might be gas. Clamor says he attempted to burp the baby approximately for 10 minutes. Clamor explained that his, quote, intuition is usually good, and often when Vanderbeck thinks something may be wrong with NC, Clamor tells her that he will be fine, and he is, but this time Clamor felt it was different. When symptoms did not improve, Clamor contacted a triage nurse around 1400 hours and was instructed to call 911, 1400 hours being about 2 o'clock in the afternoon. Now, Clamor said that due to the automated phone system, the triage call lasted approximately 11 minutes, and he called 911 immediately after that call ended. But this is what police say in the report, because based upon their review of Vanderbeck's text messages and videos and the interviews of Clamor and Vanderbeck, it appears that approximately an hour elapsed between when they first noticed that NC was in significant trouble and when they actually called 911. Now, when you look at Clamor and Vanderbeck's alleged accounts of what happened, it is terrifying to think that they waited a full hour to call emergency services after seeing their infant child in the condition reported there, and not to mention their alleged attempts at trying to get the baby to respond, including more shaking, burping, and forcing the child's eyes open. Now, at this point, the situation, frankly, it's dire. And the baby was subsequently rushed to the hospital in critical condition. And now I want you to remember those police interviews that were done the day after the baby was sent to the hospital. So you fast forward 3 days later, and what's reported by police, it's shocking because investigators also located a video that Vanderbeck, the mom, put on TikTok. This was on March 8th of this year, 2026, where she is seen slowly dancing. According to police, the video, we believe, has been taken down, but it shows her dancing slowly in the bathroom of her baby's hospital room with what can be described as, quote, upbeat music playing in the background. So according to the affidavit, Vanderbilt published a TikTok dance video in the same hospital room as her dying newborn son. And unfortunately, her son did pass away from his injuries the following day on March 9th. Now, also mentioned in the affidavit are the injuries observed on the child, and those are so hard to talk about. According to the physician's assessment, quote, a 7-week-old with multiple injuries found on imaging, including subdural hemorrhages, anoxic brain injury, extensive retinal hemorrhages, and possible healing rib fractures of the posterior, medial, 8th, and 9th ribs identified on CT imaging. Given the lack of any reported accidental trauma and the nature of the injuries, these findings are consistent with an acceleration, deceleration injury with a rotational component with or without impact. Based on the review of the available medical evidence, this presentation is consistent with abusive head trauma. It's obviously very difficult to hear what just a 7-week-old child was going through, allegedly at the hands of his own parents. And the medical examiner's report from the infant's autopsy on March 10th and 11th is even more tragic, because based on the physical observations, including intracranial and spinal hemorrhaging and what appear to be fractures of the 5th and 6th ribs, the tentative cause of death appears to be homicide due to abusive head trauma, though this finding is not definitive until the results of pathology are returned. So right now, the full medical report is still pending from the Pierce County Medical Examiner's Office, but the current information led to the arrest of Clammer on March 9th, the day of his son's passing, and Vanderbeck's arrest following the autopsy that came in on March 11th. So the next day, now Thursday, March 12th, both of them are seen in Pierce County Superior Court for their arraignments. Let's start with the mom, 19-year-old Alyssa Vanderbeck, as she learns her charges and her bail amount.
The defendant is charged with 1 count of murder in the 2nd degree with the domestic violence special allegation as well as the aggravating factor of vulnerable victim. We're asking that bail be set in the amount of $1 million. We do believe that the defendant poses a significant flight risk. First, the defendant, as Your Honor is aware that she's charged with the death of her 7-week-old infant child who we believe died by cause of death of abusive head trauma. The full extent of the injuries are unknown, as we have not yet received the full pathology report. There is information to believe that there were multiple ribs within healing stages, and therefore elevated charges of homicide by abuse could be added. In addition to that, we know that the defendant is unemployed. She had little familial support, and that she called the co-defendant from the jail indicating he needed to pay rent and that she may be getting an Airbnb. For all of those reasons, we do believe she poses a significant flight risk, and that significant bail in the amount of $1 million is appropriate.
In this case, we have what is mildly described as a very vulnerable victim. And I don't think that, obviously, we know everything that there is to know at this point. But given all circumstances here, I'm saying bail in the amount of $1 million.
So, according to the prosecutor, Alyssa is charged with 2nd-degree murder with a domestic violence special allegation, along with an aggravating factor of a vulnerable victim, and in this case, a newborn. And the judge agreed to set her bail amount at $1 million, which still stands today. As for 21-year-old Mark Clammer, here is how his arraignment went.
The defendant is charged with 2 counts of murder in the 2nd degree with the domestic violence special allegation as well as the aggravating circumstance of having a vulnerable victim. Your Honor, we're asking for bail in the amount of $1 million as well as no contact with the co-defendant, the reason being that we believe the defendant poses a significant flight risk. In addition to being unemployed and the evidence that we have little familial support, these charges could be elevated to homicide by abuse pending the pathology report, which indicated that according to previous reports indicating that the victim here had multiple ribs in healing stages, and therefore additional charges could be filed. So for those reasons, we do believe that high bail in the amount of $1 million is appropriate.
He is charged with 2 counts of 2nd-degree murder with the same special allegation and aggravating circumstance as Vanderbeck, and the same $1 million bail was set. The prosecutor also mentioned homicide by abuse could be added as an additional charge for both defendants once the full pathology report comes back, and that's based on the healing rib fractures mentioned in the physician's initial assessment. Now, regardless, according to Washington state law, the maximum sentence in a 2nd-degree murder charge is life in prison, so both of these parents could face serious punishment if convicted of these counts. According to each of their court dockets, both parents are due back in court on April 8th. That will be for a pretrial hearing, and we'll be keeping a close eye on how that plays out and what justice will ultimately look like for that 7-week-old baby who lost his life, a life that should have been just beginning. Joining us now to talk more about this case is Mark Weaver, prosecutor and former Deputy Attorney General for the state of Ohio. Always great to have you on Law and Crime. You know, this story is just hard to find words beyond just saying how brutal it is. We do have some social media posts and some pieces of the affidavit that I did want to go through with what the two suspects, the parents, allegedly told authorities. One of them from the affidavit reads that Clammer, who's the dad, was emotional, tearful at times, and appeared exhausted. He expressed ongoing stress related to finances, housing, unemployment, and exhaustion from childcare. And he stated multiple times that he believed in God and was afraid for his son's life. Then we have some social media posts from the mom, Vanderbeck. Couple stood out to us. One on January 23rd, the same month that her son was born. She posted saying that she, hates feeling like she's the worst mom to exist. And then on March 3rd, which was the day before the incident allegedly happened, she said, finding a babysitter so me and Mark can both go back to work is going to be hard. I think it's hard for people to hear these allegations and to find any sort of sympathy whatsoever for parents who would be accused of a crime like this. But when you see some of these cases, how effective can the defense be that this was a couple that were in way over their head, leading to the horrific injuries that this boy suffered?
You can imagine the defense lawyers for these two people will be trying to pick jurors who they think will be sympathetic with parents who are clearly beyond their own capabilities. That can work. That's not a legal theory. That's essentially what's called jury nullification, where the elements of the crime are there, the evidence proves it, but you hope the jury will feel sorry for the defendant and perhaps even not vote to convict. That might be one of the strategies we see in this case.
As a prosecutor, and you have these interviews where it doesn't seem like there's a question of who allegedly hurt this baby. It's the circumstances surrounding how this baby had some very, very bad injuries that eventually took this child's life. How do you build this case effectively? And knowing that a defense attorney could argue that, hey, these, try and build this sob story and maybe just be able to pull on the heartstrings of a juror. How do you build this case effectively?
It starts with finding a really good medical expert who can teach the jury how these injuries happen. Remember, that's what a good medical expert does. They're a teacher. The reason why courts allow expert testimony is they're only allowed if they can be an aid to the jury in what they're having to decide. So a good medical expert will explain why these injuries, these healing injuries, look the way they do, how long ago those injuries happened, what likely caused an injury like that. Certainly with the death of this baby, why this baby died. So this all starts with a really strong medical expert who can speak to a jury in a way that is understandable and persuasive.
And there was a mention that there were some rib fractures on the boy that were in various states of healing. So alleging that, this incident that seems to be at the crux of what we're talking about that ended up taking this boy's life, that there were injuries beyond, prosecutors may argue, beyond just what the doctor saw in the hospital that day related to that particular incident. But how do you prove as a prosecutor that they were the ones actually responsible for those previous injuries on top of the injuries that they're facing the charges for right now?
The easiest way is to cut a deal with one of the parents to testify against the other parent. Marital privilege only applies about what a wife said to a husband or vice versa. It does not apply to things that you can see. If the husband sees the wife do something, if the wife sees the husband do something, marital privilege doesn't cover that. So the easiest way to do this is to get one spouse to testify against the other, because it's doubtful that there's video of this incident or any of these incidents. It's doubtful that there were witnesses to the abuse other than the spouse. So the cleanest way to do this is to flip one spouse on the other. Otherwise, you have to ask the jury to hold hands with the prosecution and take a leap of faith that there's really nobody else who could have done this. There's really nobody else who could have committed these injuries.
You have this TikTok video that has since been deleted. So I haven't seen it personally, but I've just seen descriptions of it where Alyssa Jade Vanderbeck, the mom, is apparently in the hospital doing some sort of like upbeat music dance as this boy is, fighting for his life. It's just bizarre to say the least when you hear about it. But like as a prosecutor and you have that piece of evidence, I'm assuming they have that video. Like, how does that go into the story that you're going to tell the jury?
Well, I want the jury to see it because it certainly goes to a cold heart, if you will, a depraved heart. The defense will file a motion saying that it's more prejudicial than probative. They'll probably file a pretrial motion saying it doesn't tell you about what happened when the baby was hurt. It only tells you about what happened after the baby was hurt. And a judge will have to decide. It certainly inflames public passion about the case because most of us, most reasonable people, that if our child was in the hospital, the last thing we want to do is to dance or to do a social media video. It does suggest some sort of, I don't know, recklessness, perhaps carelessness, or even unsound mind of this mother. Now, a defense lawyer will say, well, this is how somebody who's in grief, let's not judge how somebody who's in grief takes out their grief, and maybe this is her way of coping. But there'll be a pretrial argument about whether or not that video comes in.
What goes into when you have a husband and wife or a mom and dad in this case, and they're facing, very, very specific charges, and you're trying to make a decision, do we cut a deal with one of them? Like, what are you looking at in determining not just whether someone deserves to get a deal, but at the same time, this might be the person we really want to use the leverage against more than the other?
Well, classically, you want the person who's committed the lesser of the two crimes to be the one you make the deal with. In this case, that would likely be the mother, at least on what we know right now. She was not the one who violently shook the baby. The allegation is it's the father. Mm-hmm. So typically, in this case, you want the mother to flip on the father, although it's the mother who's doing the dance, kind of another factor. Sometimes prosecutors are looking at which of the two co-defendants is going to be more favorable to a jury. Who will the jurors feel more sympathy for? That's somebody who you want to offer the deal to.
What's that conversation like, especially when you have people who, maybe they're married, in this case, they have a child together. There's clearly a very personal relationship. I mean, how do you approach that conversation knowing that, you have a lot of leverage on them, of course, and it appears from what we're seeing thus far that the state has a lot of evidence against both of them, where if they wanted to put their foot on the gas and go all the way through a trial, it seems like it would be a pretty strong case at this point. But what is that conversation like in the room with someone when you're leveling with them that we would like your cooperation?
This is why under our system of law, the two defendants can't have the same lawyer because their interests are different. Now, they might be able to be tried at the same trial. That's possible. But they each could have their own lawyer. And so me as a prosecutor, I'm not allowed to talk to the defendants. I talk to their lawyer. And the lawyer wants the best outcome for their individual client. So I go to the lawyer of the more sympathetic, if you will, parent and say, there's a chance for your person to be out in 10 years. You want to take advantage of that chance, but you're going to have to tell me what sort of evidence they can bring in order to testify against the other spouse. So there is a powerful interest against one another because neither of them wants to, they seem to be young people. I think they're in their late teens, early 20s. Neither of them wants to wait till they're in their 50s to get out of prison.
And when you look at just the narrative of what was put together, and Mark Anthony Labaco Clammer, who is the 21-year-old father, and we've talked about, his, he was, he's alleging that he was in a really tough spot financially and the stress, and there's obviously no excuse for what happened, but he goes in because the baby wouldn't stop crying, 7 weeks old, and it sounds like shakes the child to the point that, and of course we can talk about the fact they didn't call 911 right after, and they did a lot of other things before calling medical, before calling the EMTs and then being able to go to the hospital. But just in that moment, how can that, that shaken baby type situation, how can that play out in the courtroom?
Well, every parent has had a baby crying. And it's a very frustrating thing, particularly if you're tired and you're worried. But nearly all parents know you don't shake a baby. You never, ever shake a baby. Whether or not the baby is going to die, it's just not good for the child to shake the baby. And it's certainly not going to stop them from crying. But goes back to the jury nullification issue. The defense would want to find perhaps a recent postpartum mother or someone who remembers what it's like to be stressed out and having a baby cry and doesn't want to be too harsh on someone like that. There is something that used to be called, some people still use the term shaken baby syndrome.
Right.
And the defense lawyers have actually organized against this, and they put on classes for other defense lawyers and point them to medical experts who will say that's not a thing, who will try to undermine it, who will come in as an expert and say, you can't say that shaking a baby leads to their death, and that the notion of shaken baby syndrome is junk science, is what they'll say. I don't think that's true. I think the average person knows that if you shake an infant, you're going to injure that infant. And we all know that the brain sits inside the skull and floats. And so the more you shake it, the more injury to that brain can happen. But there is a lot of evidence out there now and a lot of practice out there that seeks to undermine the notion that you can kill a baby by shaking, or if you can directly prove who caused the death through shaken baby syndrome.
Wow. So, and is that because you just hear it, and I'm just like, as someone who maybe if I'm a juror, and someone who has kids myself, like it just, if someone told me that, this won't lead to a child's death, especially 7 weeks old, when you think of how delicate a child is, and I know that you haven't particularly dealt with this type of defense, maybe, but like, is it like in the prosecutor community, like, is that something that you really have to worry about? Like, is that proving to be an effective defense in some of these cases?
Well, remember, prosecutors have all the burdens. We have the burden to prove our case beyond a reasonable doubt. And we have essential elements to every crime that we have to prove beyond a reasonable doubt. And so the experts hired by the defense, and it's a cottage industry, these experts make a lot of money. They are paid to come in and bring certain kind of testimony to the table. They will just go for one particular element, probably the causation element, right? So you can prove it was the defendant who had the baby. You can prove that the baby died. You can prove that the defendant shook the baby. But can we really know what that baby died of? How do we know there wasn't some sort of condition going on in the baby's brain that made it vulnerable? I think it's a lot of nonsense, but this is the sort of stuff you'll see defense lawyers pushing back on. And you only need one juror to believe it, because if one juror believes it and they vote to vote not guilty, now you have a hung jury. And you have to go through the trial all over again. And maybe the defense lawyers get another sympathetic juror. And so in the world of defense counsel, they have a lot of experts ready to come in and undermine what you and I know to be pretty common sense. If you shake a baby, you could kill a baby.
And even if, and we don't know what their defense is going to be, but they did not immediately call 911. I mean, there is a lot of evidence, it seems, from prosecutors that this couple did a lot of other things instead of calling 911, which is definitely what you should do in these situations. No matter what their defense is about that particular moment, how does that kind of pad the prosecution's side of it, being able to say like, okay, this happened, and whatever the explanation that the defense may come up with, we know on the other hand, not just do you have this TikTok video, but you also have a period of time where this baby should have been going to the hospital, but it wasn't.
This is much more powerful evidence than the TikTok video. We do have to prove, in order to get to the most serious crimes, you have to prove a certain mental state. Latin is mens rea, state of mind. And not calling 911 is evidence of consciousness of guilt. Everyone knows that the police work with 911. And when you call 911, you might have ambulance come or medic. You also may have the police come, and they may begin an investigation. And so the notion of taking videos of this baby and then emailing them or texting them to other people for getting their opinion, certainly that's recklessness. That's enough to be convicted of a lower level crime. That's enough to have a child taken away from you. But whether or not it proves that you ought to be convicted of this higher level felony that gets you 10, 20, 30, even life in prison potentially, that'll be up to the jury.
And we'll see what happens next. No doubt, just a heartbreaking case. These child abuse cases are never easy to talk about, but this one just with so many shocking elements to it. Mark Weaver, it's always great to have you on Law and Crime to help us break these cases down. We appreciate it.
Thank you, Chris.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify, and we're also now streaming on Peacock. I'm Chris Stewart. We'll see you next time.